Hi everyone, today I want to talk to you about whether or not you can refuse an inheritance. So why would anyone want to refuse an inheritance, you might be thinking. Although it's surprising to many, there's several circumstances when declining an inheritance can be beneficial. The law does permit you to refuse an inheritance if you comply with certain strict requirements. The legal term for a refusal of an inheritance is a disclaimer, which is defined as an irrevocable and unqualified refusal to accept an interest in the property. Let's talk about when disclaiming an inheritance may be beneficial. The first reason would be to avoid or reduce the estate or gift or income taxes. In 2020, the federal estate tax exclusion was over $11 million for an individual and over $22 million for a married couple. This means that only estates that exceed this amount would be subject to that estate tax. But most people don't have such a sizable estate, so using a disclaimer to avoid federal estate taxes is less common now than it was in the past. And who knows if those numbers will change, as they do change frequently and they're set to come back down again. However, in some states, like in Massachusetts, there's an estate tax that has a much lower value, and that's if an estate goes over $1 million. So if your estate will be subject to those taxes, disclaiming an inheritance may make sense if the next beneficiary in line, as named in the will or under state law, is taxed at a lower rate than you. In addition, a disclaimer provides a way for you to provide a gift to the next beneficiary in line without having to worry about the gift tax. If you decide to disclaim an inheritance for tax purposes, it is considered to have never belonged to you. Obviously, you cannot make a gift of something that was never yours. As a result, it does not count towards your annual gift tax exclusion of over $15,000 for an individual or $30,000 for a married couple, or your lifetime exclusion amount of over $11 million for an individual. If your inheritance is an asset that produces income, such as an IRA, it will likely shift you into a higher tax bracket. A disclaimer may be beneficial if you don't need that extra income. Of course, the next beneficiary in line will also benefit, especially if that person is in a lower tax bracket. Another example of where disclaiming an inheritance may be beneficial is refers to the eligibility for certain benefit programs. If you're trying to qualify for certain government benefits at some point in the future, and the inheritance would jeopardize your eligibility, disclaiming the inheritance may enable you to become eligible. Now, there's a little bit of a warning here. For some benefit programs, an effective disclaimer must occur several years before you apply for that aid. Generally, government benefit programs will not allow you to disclaim an inheritance when you're already receiving aid in order to maintain your eligibility. Or if you do disclaim an inheritance, you may be disqualified from receiving those benefits. Check with us to make sure that a disclaimer will not be viewed as invalid under state or federal law. And it may make sense to allow the inheritance to pass to another beneficiary. If you don't need the inheritance and the next beneficiary in line does need it, a disclaimer can allow it to pass to that beneficiary with minimal expense or hassle. It will not be counted as a gift from you, so you will not have to worry about the gift tax. A disclaimer can also be used as a way to correct uneven inheritances. For example, if a parent intended for his two children to receive inheritances of equal value, but one of the children receives an asset that has decreased significantly in value from the time that it was drafted, the child who received the inheritance of higher value can disclaim all or part of the inheritance to help realize the parent's original intention. This strategy will only work if the person who received the smaller inheritance is the next beneficiary in line. It's important to keep in mind that the person who is disclaiming the inheritance has no control over who will receive the inheritance after the disclaimer. The identity of the next beneficiary in line is a person named in the deceased person's will or trust, if there is no will or trust. The person specified under state law will be the next person in line. So what are the requirements for a qualified disclaimer? Some aspects of disclaimers are governed by federal tax law and others by state property law. Under federal tax law, which regulates how disclaimed property is treated for tax purposes, a qualified disclaimer must meet the following requirements. The disclaimer must be in writing. The writing must be delivered to the person controlling the property, usually the executor or the trustee. The writing must be delivered within 9 months after the interest was created or the disclaimant turns 21, whichever is later. The disclaimant must not have accepted the disclaimed interest or any of its benefits, except for a distribution from an inherited IRA under very limited circumstances. And the property must pass without the direction of the disclaimant according to the decedent's plan of distribution. State law controls which types of property can be disclaimed, as well as the requirement for a valid disclaimer. The laws of some states mirror the federal tax law, but others have different requirements. We can then help ensure that your disclaimer is valid under both state and federal law. Disclaiming an inheritance is a strategy that you may not even have considered, but it may be able to help you achieve your estate planning and tax saving goals. We can help you evaluate your individual circumstances to determine whether a disclaimer will benefit you, and we can assist you in avoiding any possible pitfalls. Give us a call today to set up a meeting if you are thinking about and considering not accepting an inheritance from a loved one. Thank you for watching. I'm Kelly Longtin from Kelly Longtin Law.